Hello and welcome to another live Hill and Ponton QA on Veterans Benefits. Matt Hill here with Carol. Ponton, it's been a while. We're excited to be back together. I've had to carry the burden of speaking not just my truth, but what she thinks is really true on top of me. So I'm glad for her to be her own mouthpiece this time.
I'll keep you straight.
I know you won't. All right, well, let's jump into it. Angel, good to see you. Greetings. When preparing a 4138 for appeal, is it better to submit one for each condition, or if possible, include all conditions in one form? Thank you. Well, first of all, I wouldn't, that's not your appeal. You need a specific form. Either you're submitting a new claim, a supplemental claim, or a higher level review. So you need to use that form. As far as whether you put everything, I would put everything on the same appeal letter.
Yeah, I would.
You don't want to create 4 or 5 different appeal streams and then be chasing every which one.
Remember the VA changed the law maybe 8 years ago. And if you don't file the proper form, even if you do file the proper form, you're probably going to get a letter saying you didn't file the proper form, and they won't proceed until you do. So remember, if you filed a supplemental appeal, you can file a higher level review, or you can go to the board. Or if you don't have, if you want to file and put in new evidence, you can file another supplemental appeal, which is an 0995. Okay. So make sure you use an appeal, and then you can put on that appeal sheet all of the arguments that you have.
Good question. Jay Monk, good to see you. Recently denied sleep apnea. After reviewing the ACE report, I noticed the VA stated my sleep apnea did not affect my work conditions, which is baloney. I have a statement from PEEP saying that they have seen me fall asleep at my desk. Is this worth reappealing? Can I do another higher level review? You cannot do another higher level review unless you did a supplemental in between.
And it's not worth going back to the VA because they're going to deny you again. Go to the board.
But I think we're talking about 2 different things there, Carol. He said he got denied sleep apnea, which means you were denied service connection. But then the evidence you're speaking to, falling asleep at the desk, that's the evidence of how severe it is. So we got to get service connected first.
Right. And if it's severe, you know, what we're really doing is trying to get service. They're not going to, clearly, they're not going to do it there. I just think now that the board is moving. It's not always right. It's not always, but a lot of times it is. And they are moving. If you have the evidence in and it was there before the first decision, then you can go directly to the board. I'm getting some decisions back in 2 weeks, 3 weeks. So especially if it's a simple one issue question. Okay. So don't, on things like sleep apnea, if they've denied you several times, please don't stay there. Go to the board.
Sleep apnea is one of those sticky ones that they don't like for some reason.
And remember, the regional office is supposed to, but they don't pay any attention to these buddy statements. So the board is supposed to and usually does. So once again, that's where you need to be.
Oh, JMonk 103. In past, you talked about presumption of soundness. I get it, but I'm still confused in my case whether I should continue to appeal. My case is that the VA said I already had lower back strain before joining the military due to my initial physical exam, but this was a mistake on the form. I accidentally checked the box in the form, and it was crossed out as no, not yes. I accidentally checked the box in the form, and it was crossed out as no, not yes. VA is now riding the high horse saying that I had this condition prior to military service. What can I do if I reappeal? This is one I'd say with Carol, I'd go to the board on this. I mean, you have the presumption of soundness, right? Your military entrance exam did not show anything happened before service. You crossed it out. That they should have just read that as it was. They haven't. So if they're saying it started before service and there was nothing before service, then presumption of soundness is what you want.
And remember, you checked the box, but then the doctor evaluated you. If the doctor put there was nothing there or asymptomatic or didn't even mention your back, you have the presumption of soundness.
Yes, she's right. The doctor's report is what really matters.
And remember, this is just another one that, you know, there's certain ones that we know don't mess with the regional office. You're not going to win there. This is one of those. Go to the board. And you need to point out exactly what happened. It was crossed out as no. The doctor said that you had no problems whatsoever.
Or didn't say anything.
And you have the right of the presumption of soundness. The VA at the regional office does not get it. This is very typical.
This is definitely a nuanced legal issue that, you know, non-juris doctorate adjudicators are just not going to get. You know, you need the judge in this case.
Right.
That's what I would say. Happiness, good to see you. Are you aware of any protection for caregivers with jobs when expected to travel for business but unable to? I know there's a respite, but that wouldn't cut it. Time to quit after 18 years, part 1. Caregiving is tough, but someone has to do it. Hopefully the stipend will and can come through with approval. The caregiver is taking so much longer on supplemental than the denial did. Also, do you know anything about bruxism? Does it have its own DBQ? Will it be sufficient for dentists to write a nexus only when we have plenty of evidence and x-rays? Let's get back to the caregiver ones first. I am not aware of any protections with the caregiver, unfortunately. I mean, the Family Lead Act might cover you, but nothing. Yeah. Student or caregiver. And then, as far as bruxism, DBQs really cover the extent of the disability. We could go to more of the rating versus if you have a dentist who's willing to give a nexus. Again, you got to have something for him to look at in service. There's got to be something besides the veteran statement showing something happened in service. But you have that, you have the current medical records, and he can connect the two. Great. You don't need a form for that.
And the dentist is perfect.
Vet, legacy board remand are denied again. On my SSOC, my current evidence was not listed or considered. Better to reply to RO or point out that the non-considered evidence when it gets back to the board. Back in the legacy system, I mean, you've got a case that's been going on forever. Yeah. It's 93% of cases that were remanded to the RO were sent back on SSOC. I wouldn't bother with the RO. I'd wait for it to get back to the board. I mean, there could be something in the SSOC that states considered such and such rating decision and all evidence therein. That would include the prior evidence that you're talking about. But I would fool her, not the RO.
No, go to the board.
She's big on the board today. I don't know if you guys have noticed.
Hey, we for years we could not go to the board, and we just agonized at the regional office getting the same denials, and now we have the board. And boy, I'm telling you, this direct review, I mean, we get denials, but we're also getting approvals. We're at the regional office. You're just going to get a denial on a lot of these issues.
No. See me 44. 1, intent to file 12/26/22. I filed a claim on 6/13/23 for PTSD migraines. Denied 12/22/23 for PTSD migraines. Filed higher level review 1/26/24. DRO founders DTA on
duty to assist
on 5/24/24. Then denied again on 10/25/24. Filed supplemental on 12/1/24 for PTSD migraines. I was awarded 30%. PTSD features and migraines on 2/10/25. Yay, thank you. Hold on.
Yeah, effective date.
Hold on. Go back. Oh, she's just saying. Okay.
Right.
Okay. That's the day you were awarded. Great. I'm so glad to see that. I thought you were telling us that they screwed up the effective date, but no, that's wonderful to say. It doesn't give the effective date. But
if the effective date isn't when you filed, make sure you go back and file a higher level review. What was the last thing you filed? A supplemental, file a higher level review. And normally what I see is they give you, after all of this back and forth, they will give you service connection, but then they only give you a recent effective date. If this happened to you, file a CAR higher level review because they are really quick to correct that. That's one place that I do go to the regional office, and we find really good luck there. So don't take.
But if they did get it right, congratulations.
Yes.
You fought a long, hard battle and didn't give up. We're happy to see you did that because you got the money.
Good for you. But ask for high rating.
Timothy, good to see you. Part 1. Currently rated 100% for PTSD independently since 2019. So have some protection of the 5-year rule. Want to submit a claim for aid and attendance, but clinical psychologists won't complete the VA form 212680. I do have notes from him along with other VA providers stating I need help with my medication management, suffer from impaired memory, have left stove on, need help with meal prep. Migraine doctor stated as well in his notes that when I experience debilitating migraines 6 to 7 times a month, I need help bathing in the toilet. This is tough because you're going in and you're going to be depending on their doctor to say that you need aid and attendance. If you need it, here's the thing about the migraine 6 to 7 times a month. You have to have this daily. It's activities of daily living that are affected daily. So, with the stove, that's a hazard every single day.
Mixing up your medicines if you have to every day.
So, you know, I don't feel like I have enough information to advise you here. If you did go in and you saw some P examiner, make sure you take the doctor's notes stating, if you go to part 2, Nate, go back. You know, health and medication, suffer impaired.
Left the stove on.
So make sure you take those specific notes and say, look, I've had these problems. Here's where I spoke to my doctor about it. You know, and I would go from there.
You never know. I just got a really favorable aid and attendance compensation and pension exam. So you never know what you're going to get. But if you have notes like that from your doctor that show those significant problems, that gives you a leg up, depending on the examiner you got.
David Peter, I'm rated 100%, heart disease 30, stage 3 kidney disease 20, diabetes type 2 20, prostate cancer residual, 10% hypertension, bilateral diabetic peripheral neuropathy 10 per foot. Recently found I have hyperparathyroidism and want to know if that's caused by Agent Orange exposure. All my disabilities are either AO presumed or secondary to AO presumed disabilities. I am concerned that because I won't have 10 years at 100% until I'm 82. I'm going to do everything I can to make sure my wife gets DIC.
Okay, one thing about it's hypothyroid. And one of the things is I often see a very
hypoparathyroidism. Go back.
Yeah, he said hyperparathyroidism.
Yeah.
All right. Well, what I'm saying is you always want to make sure this is going to give you something that makes it worth rolling the dice. And I'm telling you, I see 0% ratings for this over and over again. So I would need to know more. If this is causing you real problems, not just medication like 10%, then I would file it. If not, I don't think I'd mess with it. Now, if you've had surgery, if you've had, real problems, then I would go for it. But I'm just telling you, you always need to look at what you're going to get for that. And across the board, I'm seeing really low ratings for that unless you've had some significant problems that are documented.
Well, he doesn't care about the rating. He cares about setting up for DIC. So for DIC, for your wife to get that, should you die before her, she would have to show that the problem was that you died directly as a result of a service-connected disability or that you had a service-connected disability that was contributory towards death. So if we go back, Nate, once.
You've got a lot of things that are more likely to cause.
Heart, kidney disease, diabetes. I mean, so even if your primary cause of death, for some reason, hypertension is a huge one. Even if your primary cause of death wasn't one of these,
they have to have contributed to it.
Exactly.
So I wouldn't worry about that for that issue. I'm asking you, why don't you have SMCS? You've got 100% for one thing. You should have, and you've got 60% combined for others. You should have SMCS. Do you need aid and attendance, or is your peripheral neuropathy gotten worse? Those are the things that you should be looking at because that can give you more money. And that, remember, you want your wife to get benefits, but remember, she's only going to get like $1,600 at the most, maybe $1,900 a month. So if you can get more money now and save that, that's because that's big money once you start getting loss of use of feet or aid and attendance, and that's a lot more money that would go toward your wife or for your family.
Richard, first claim. Had VSO help do claim? Over 1,000 pages SBR and personal medical records. Claim was for migraines, mood disorder, both knees. First time, all denied. VA stated no evidence. The employee requesting that CD, which shows they did have records showing vehicle accident service with treatment for this, multiple injuries, also showed quad strain treatment. Did a request to review, receive while your service records reflect complaints, treatments, diagnose similar claim. The medical evidence supports the conclusion. Was not presented in service. Although there is a record of treatment and service for knee problems left, no permanent residuals or chronic disability subject to service connection is shown. You have been diagnosed with a disability. Private medical records show treatment for osteoarthritis of the left knee. Evidence shows that a qualifying event, injury, or service had its onset during your service. Treatment records show that you had a complaint with left knee pain. Advice as I'm seeing an ortho doc for this. Thank you. So again, this is the beauty of this new system under the AMA. They have to tell you what you do have. Okay, so they told you have a current diagnosis. They told you that you did have something happen in service, even though they're saying it wasn't significant enough. That's kind of nonsense. What you need now is a nexus. You need a doctor, hopefully your doctor, connecting those two issues, showing, okay, this is what happened in service. This is his current disability. This is how what happened in service, a vehicle accident, could cause this orthopedic injury.
Exactly. And remember, you need the doctor to say, I've reviewed the service medical records and your personal records, and great, I'm the treating doctor. And having looked at what happened in the service and his current injury, I think it's more likely than not that what happened in the service is causing the present diagnosis.
So take those service records to him, whatever shows the accident, and treatment you have, and then you go from there.
Right. The great thing about this is you don't have to wonder what's missing. Right now, you know what's missing.
Zeb, good morning. I had a car and they found duty to assist. Do they usually give another C&P exam or just to correct the error on the last C&P exam? If they said it was a duty to assist during the C&P exam, they're going to send you for another one or send it out to a question.
Yeah, for a different medical opinion. So you may get a C&P exam, or it may be that they just want somebody to look at the evidence again and say something that they're not sure of. Diagnosis, service connection. So often I find that's what they're looking for rather than another exam, but it could be.
Another step, good to see you. When I was deployed, I worked in and around buildings that have now been closed due to contamination, mostly in Iraq, military and government buildings. Many bombed out or in various states of damage. How do I find out what I was exposed to? For health reasons and in order to support claims. History has shown that that Vietnam veterans and Camp Lejeune Marines were not informed for decades.
That's the truth.
That's tough because you were in Iraq. If you were in the U.S., and they closed down a base, they'd have to do an environmental study and talk about what toxins were there. I don't think they have the DOD any obligation to do something like that in Iraq, so I'm not sure what you would do.
Yeah, and unfortunately, Iraq, there are just so many things that you could have. I think really it's just unbelievable. So I think in this case, you just need to see what issues come up for you and file for them, because it pretty much covers a lot of stuff.
Sharon Johnson Cowart, one of three, filed a claim for GERD and was denied, and then filed a higher level review, which was also denied for the following reasons. The previous denial of service connection for GERD as secondary to post-traumatic stress disorder with adjustment disorder with depressed mood, chronic, is confirmed to continue. I never mentioned my GERD diagnosis related to PTSD. I personally believe the GERD is an outcome of asbestos exposure. TERA memorandum dated April 26, 2023 concedes exposure based on duties as a hull maintenance technician has a high probability exposure to asbestos. How do I proceed? Okay, so this was at a higher level review, so you cannot do a higher level review again. So you have two options: supplemental claim with more evidence, or go direct to, you go to the board.
The board's just going to send it back, I think. So I think what you need to do is file a supplemental claim and submit all of those articles and medical treatises that show the connection and allege that my claim was not evaluated correctly. I am alleging service connection to GERD related to this, not to the PTSD. Although remember, sometimes GERD can come because of medications that you might be taking for PTSD or anything that's service connected. So I would also look at those, because you want to, as many options as you have that are viable, you want to make sure you pursue those. So I would look at the medications you're taking for any service-connected problem and see if that relates to GERD, and also pursue this one as well.
Yeah. So as far as you're going to need new relevant evidence here, the TERA memorandum, unfortunately, is not new and relevant, but I think a statement talking about what you did in that MOS, working on the hull, working on hulls of ships, and maybe if you saw asbestos, you need something basic to open the door back.
Well, a definition of her MOS. I think that's what she needs to start with.
Okay, define your MOS, and then just a short paragraph about what that was. I'd attach the TERA memo, and then if you have any articles showing that that asbestos causes GERD, we just need something in the record so they don't come back and say there was no new material evidence for a supplemental claim, but denying it for that reason, because that takes you down a whole nother rabbit hole. But I agree with Carol. Going to the board here is a waste of time because they're just going to send it back. It's very frustrating. I hear you as far as they didn't even evaluate it, what you'd asked them to, frankly, what the evidence points to with the TERA memo. So it's one of the few times they do a TERA memo right, and then they still screw it up.
But this is what we've been talking about. I've been seeing these crazy medical opinions, like, I have headaches. I've had them since service and they deny them because it's not related to a toxin, which was never involved. So, they just don't know what they're doing, and you have to point it out specifically as to where the error is.
So this is where you need to persevere, Sharon. I'm sorry you're going through this, but it's kind of like what our previous folks have written. It's like deny and just keep on pressing. So again, supplemental claims are less here. And one of two, filing husband's fully developed claim, Camp Lejeune prostate cancer. Service treatment records copied from microfiche, barely readable, but did see some of another vet's STRs mixed with this. Not sure if we should notify VA before filing a claim or not, trying to avoid any delay in processing this claim. Any thoughts? Thanks for all that you do.
Please don't delay filing a claim.
Yeah.
Please always file and then point out that the records are mixed up and they're illegible, and ask for, a real copy that you can understand, and get rid of the records that don't belong to your husband.
Yeah, I mean, if you have them, don't submit them. But if they're already at the National Personal Record Center, VA is going to get a copy of those. So
it's on microfiche, she said.
Yeah, I mean, if they're not in your possession, I wouldn't worry about it. But as Carol said, the focus is your husband's claim. Go ahead and file it. Make that. Tiny. Hi, can you please explain the response time for decision of a claim after judge hearing of remanded cases? Does the claim become redocketed and further delayed? My claim is in the legacy. Today is the 90th day since my hearing with the judge.
Wow.
So the problem with the hearing with the judge is that they're not obligated to decide the case with any time frame after that. So as Carol said, there was actually a period where they were rushing through all these hearings and the cases were sitting for 3 or 4 years. That hopefully is over, but it still can be 3 months, 6 months, 8 months for them to make a decision afterwards. So unfortunately, we don't know. And as far as a remand, it's in legacy. If it's in legacy, the docket number at the board should always stay the same. You can call them and ask them, what's my docket number? Your docket number will be on the BVA last decision you had, just to make sure. But it should not change. That is one of the benefits of legacy, is that you keep your place on.
Unlike the new system.
Right.
And remember, if you have any basis for expedite, 75 or older, homeless, suicidal, lights and or electricity turned off, or threatened to be turned off, or eviction threatened, or foreclosure, any of those things, file a motion to advance on the docket and put that down there. But that's, we hate hearings, and that's just one of the reasons why. It's crazy. You would think they want to make a decision
right then and there when it's fresh.
But this is what happens.
Sometimes it's kind of mean. I feel like they're just kind of watching you and doodling on a piece of paper and paying you attention, because they don't. It's like they don't even reference the damn opinion hearing when they get to their opinion 6 months later. But that's unkind. All right, what else we got? Oh, 3 of 3. Also, can you guide me on what I should do for opening a claim for disability that I recently developed at the hands of a doctor whom I received community care, VA contract doctor? So that would be, is it 1151, Carol? 1151 claim?
Yeah, 1151.
It's a VA medical malpractice claim. Basically, you got to show that the VA doctor did not use the standard level of care, and due to that, you received disability. And then they compensate you. They compensate that disability as if it were service-connected disability. So it'd be under the same.
But remember, you have to show negligence on the part of the doctor. There are 2 ways you can do. You can actually file a federal tort claim, but then you really have to file. That is very expensive. It takes a long time, and then also it is very hard to get another doctor to say that another doctor committed negligence.
Yeah.
At the VA system, it's still hard, but not nearly as hard.
And the difference would be, in the federal system, you would get some kind of lump sum payment. Okay. In the VA system, you would get the ongoing benefit. So, the lump sum hopefully would be a lot more initially, but it'd be one sum. Yeah. And then the VA would be something ongoing.
Right.
Mr. Williams, Ms. Carroll said BBA was already working remands about 60 days to decision, but my paperwork I received in December said they worked cases on my VA Form 9 that was received in May 2020. I was wondering if you've seen cases take 7 months to decide on remand. My appeals from 7/17. Okay, so
Is it a
Carol,
legacy?
yes, yeah.
Okay.
Carol's talking about, we got two systems still. We got the AMA, which is the new system, which we're seeing turnover happen a lot faster.
Yes.
She's seeing 1 to 2 weeks.
No, I said
think
it can be.
I think she's seeing things. I ain't never seen that. Okay. But it is happening a lot faster.
Yes.
Now, these legacy cases, they are old. They're all super old because there's no more new cases as of like 2019, 2020. So
They're
you are
old, so
stuck
they're
in a-
huge.
Yeah.
So when the judge gets to them, it takes a lot longer, and that's a problem. The ones that are stuck, now some of the SSOCs are coming back really quickly, but a lot of them are just sitting there, and I'm wondering why. But I would definitely do a letter to the BD asking for the status, because that is a long time. Yeah. I'm not
Well,
seeing
hold on.
that.
Go back. Was this one of two? I think BPA was working remands. I think if it was remanded, then it's back at the regional office. He's saying 7 months there.
Well, but he's saying work cases might.
Yeah, I don't know.
Oh, the regional office, forget it.
If it's Carol saying if it got back up to the board, do what she said. But if it's at the RO because it was remanded, 7 months, fortunately not long, but I would still contact them and say I want a status on this, because they should have been, if it asked for a CP exam or medical records, like you should have been seeing movement by now.
But that's not unusual, unfortunately. My
Dover Trans LLC. Okay.
My LTF.
ITF. Yeah.
Oh,
it's
ITF.
It's from 2022 for mental health, and I've been appealing it since then, never over 12 months in between. So that means you have consistently appealed. Our effective date is that 2022. If it's granted secondary to migraines, if it's granted secondary to migraines 7/24, will it go back?
Will it? I don't know, but it should. Yes.
Well, no. If migraines wasn't granted until 7/24, then
it's granted second to migraines. If it's granted second to migraines on 7/24.
Okay. If your migraines, so let's do two scenarios here.
Okay.
If migraines have been cervix connected this whole time, let's say back before 2022, then yes. Theory of the case does not speak to when it's granted, all things being equal. Meaning you file for mental health, you already have migraines, and you say, I think this is directly related to cervix. And they say, no. And you say, okay, I think it's related to migraines. Well, if that's within that continual appeal, as you said, between those 12 months, it goes all the way back. Now, if you were just granted migraines on 7/24, it does not. It goes back to the date that you're granted migraines. Robert, thanks for your free book. In a matter of months, I went from 80% to IU 2 hours. 2 hours. How about that? After a high-level review, there was a pending deposit for back pay, first recurrent monthly. Robert, that is great to hear. If you wouldn't mind sending in an email, because when we constantly reprint the book, it's nice to actually have real vets speak to it on the back so other vets feel more confident as far as, because the book is my playbook, guys. I mean, it's what Carol and I have developed over the last 2 decades on how we win cases. We can't represent every vet that comes to us, so we just put it out there as far as what you can do, and hopefully you can win yourself. So it's great to see, Robert.
Great.
Thanks for that feedback.
Congratulations.
Step by step. Received a grant for caregiver benefits back to 2018. Haven't received anything since the initial letter. What happens next? National Caregiver Review. It's only been a month. Any clue on timeline?
No,
timelines doesn't make sense to me. I mean, you should have received benefits. If they issued you a decision letter, the decision letter is supposed to be coupled with any retroactive payment. But again, this is a VHA doing it. So
yeah, it's a VHA, and I don't know because they're so erratic. But I would definitely contact them and ask them what's going on, because you should have been paid.
Yeah, and that should be
a big sum.
Yeah.
Do you have, and if you don't have direct deposit, remember you should get direct deposit set up with them. That means calling and setting up your.
Well, he's got to have. He's had a substitute here with us forever, and I know he's started service connector stuff. So yeah,
I wonder if caregivers paid separately from the VA.
Good point, because it's the VHA, not the VA. You would think all of them would talk together in their systems, but
nope. So call the VHA and make sure you have direct deposit set up. Okay, you don't want to check floating around out there that you don't know about.
This could be a good spot to grab a VSO to look on their system to see if they have anything going on here.
Yeah.
But I'd do both those. Hurley. 1 of 2. Filed for exposure to heavy metals, chlorinated solvents, PCB exposure, asbestos exposure. Asbestosis Granted, toxic exposure elements deal leal and deal blah, blah, blah. We're going to say bad toxins, okay? Because she's going to make fun of me when I try to do this. Holy moly, what was your MOS? What is that? I don't know what that is. And I don't know why. Okay, this doesn't make sense at all. I frankly want to see this decision because
if you got granted,
you don't
fight with it.
No, but you don't get granted for exposure. You get granted for disability. So, like,
Right.
You don't get granted for Agent Orange. You get granted for prostate, diabetes, or something related to Agent Orange.
I
So,
thought you got granted. I don't know.
okay.
Oh, it's granted that you were exposed to those.
Oh, they're conceding exposure. Okay. And you're saying those are the wrong toxins. Could those be elements of PCB? It would be my question. I don't know. This is where, unfortunately, Carrie, our chemistry professor, really handy.
From Kentucky.
Yeah, chemistry. I don't know that, but what I do know is you got to make sure if they're conceding that, then you want to say, okay, well, then does it cause these disabilities? Because they're not going to service connect you for exposure. They're going to service connect you for a disability caused by the exposure. That is some serious stuff. If you wouldn't mind letting us know what your MOS, I'd really be interested because that's
Yeah,
intense.
and I can't believe that wouldn't cause just about anything that you have a problem with.
Yeah. Todd, when does VA progress prostate claim? My rep put it in October 1, had prostate removed February 10th.
When does the VA process the prostate? It should have done this by now.
I mean, that's 5 months.
That's 5 months. Appeals can take forever, but supplemental claims are usually done within 6 months, and usually quicker than that. I think they've lost your case or something. I would definitely call the VA and ask what's going on. And make sure that the rep put the claim in.
Yeah, hopefully you received something and noticed that you had filed this claim.
Because you should have had a C&P exam, you should have had letters from them, something should be going on. And so you would know where you are in that. If that isn't happening, then I would really be concerned about them.
Yeah. Last 5 miles. Thank you, Hill and Pond, for all that you do. It's very much appreciated. Keep it up. We love being here and love seeing all these success stories y'all have.
Makes my day.
It also makes your day when you guys submit all these chlorophyll and chemical names that there's no way I'm ever going to be able to say. Treckham had a higher level review and a duty to assist was found for GERD and hiatal hernia. Old schedule. My higher level review was closed. What happens when the duty to assist is sent back to the rater? Is it supposed to be expedited?
No.
Definitely not expedited.
No.
The rater is supposed to give you a new decision, and then from that new decision, you can go back to higher level review if they screwed up, or file a supplemental claim, or
go to the board.
Yeah.
Duty to assist they seem to be slower than anything else.
throw them in the damn trash. I mean, seriously, I wonder if there's some kind of internal memo going around saying, okay, duty to assist doesn't count as much as doing a new decision. So we're just going to put that off to the side because we're just seeing a trend that those just get sent back.
Well, they weren't even doing them at all for over a year and a half at all. And now they're doing them, but they still seem to take forever. The other thing I need to tell you I'm seeing, I don't know what they're doing, but they have somebody going through all of the records and severing, saying there was CUE, there was error and granting. It's craziness like I've never seen before. And so we are getting, and you don't have to do anything. It just comes out of the blue. So if you're getting those, you need to fight them because every single one of them so wrong and so far has been error. CUE is clear and unmistakable error. If we file it, we have to show that there was a clear and unmistakable error. That's a non-debatable error. You can't put any new evidence.
At the time of the decision.
At the time
so
of the
it doesn't
decision.
matter if new facts, new diagnosis.
I am getting letters from the VA saying there was CUE in granting the decision because of a later C&P exam they decided to set up. Wrong. So you need to know, we see these trends with the VA, and this is the latest trend to sever or to say there was CUE in granting things. They're wrong. I have yet to lose one and to see that they were right on that. Please don't give in to those.
It seems, frankly, they're saving money. That's what they're looking to do.
It is. I've never seen anything at this level. So I'm just telling you, this is what we're getting lately.
Grace. So if you file and denied and then file HLR and the DRO finds you exist, can you then file supplemental for that claim?
Well, you can always file Okay,
No.
right now you're not doing anything because you're waiting for a decision, okay? And when you get that decision, that's a new decision, so you can file an HLR to that.
Or supplemental.
Or you only want to file a supplemental if there's new evidence you have that wasn't considered.
Yeah. Yeah. Unfortunately, Grace, you're in a waiting period right now.
Yes.
That's what we've been talking about. The abuse that's just been thrown in a hole.
The duty to assist.
Yeah, sorry, duty to assist. What's the timeline for filing supplemental and what's considered supplemental? Like, how long do you have after you've been out over a year, like out for a long time? So if you've never filed for a claim, that's an initial claim of 526. Okay?
You've never filed a claim for a specific thing like PTSD. Let's not do that. Let's say a problem with your right knee. If you've never filed a claim for your right knee, you have to file a 526. Once you filed a 526 and it's been decided, if you ever have another claim like that, say service connection for my right knee, then you file an 0995. That's a supplemental claim.
And that doesn't mean, so you get the denial, and if you want to file for new evidence in that within the year, you file a supplemental claim. You want to file new evidence with that within 10 years, you file that same supplemental claim. It's a little screwed up because if you file it within a year, it goes all the way back to the first decision. If it's not within a year,
then you're starting all over again. Okay. Supplemental claim, and when you file that, remember, you have to file with new evidence. One of the problems I see is veterans get out of the service and then file for service connection, say for their right knee. They don't show up at the exam probably because they didn't get notice and they're denied. And then 10, 20, 30 years later, they file for their right knee and they have to show new evidence, even though there was no exam and there was no evidence in there before. So remember, if you're filing a supplemental claim, you have to file new evidence, okay? Otherwise, they're going to deny you.
new and relevant evidence is what they say.
They don't give you a C&P exam like they would with a 526 at New 20.
Cynthia, any prediction on how long new mental health regs will impact vets? It would result in more lower ratings or higher. So again, Cynthia, I don't think these regs are going to come out. They were Biden regs.
They're years, they proposed them, what, 2 years ago?
Oh, 4. I think.
A long time
crazy.
ago.
And the thing is, from what I read and talking to people inside the VA, they thought it was going to be more beneficial for veterans to get a higher rating. I'm not seeing the interest for government handing out more money right now. So I have a feeling that those regs will be shelved. So I don't,
We aren't hearing anything about them coming out.
Another step, I'd love to know what you think about the new direction of leadership at the VA. Will this improve anything related to claims, process, paperwork, redundancy, transparency, FOIA, backlog, etc.? So the new secretary looks like a decent guy. I mean, he served. He was a not a minister. What do I call that? He was
Chaplain.
He was a chaplain. Seems straight up. But I think it's been made apparent from the White House that the agencies are not in charge of themselves. I mean, here's what scares me. They have 20-year-old pimply kids sitting in the secretary's office in the VA making decisions on firing people, on how they, interpret their laws and how they deliver benefits. I mean, this is being run by a billionaire South African guy. I have some serious doubts about this. And I'm really worried. The efficiencies they're looking for so far have resulted in thousands of people being fired and quitting at the VA. I don't think that's a good thing. I mean, to me, and Carol, we always say, it's like, we want the case to move forward. If they're going to deny us, so what? Great. We want it to move forward and keep on getting to where we think we can get a correct decision. But if you have less people, everything's going to back up. I don't care. I mean, they're not telling us, so the law is this, or the internal rule is this. For every 4 people you fire, you can hire 1. That math does not work for the VA. It might work for other agencies. It might, there might be places where there's a lot of people to get rid of, but we need these people in the VA. We might not like all of them, but we need them.
And my other concern is, if you give me a scenario where I can get this much money and go have another job, the people that are going to take it are the good people because they know they can go get a better job.
Meaning the people leaving VA.
The people leaving VA. So we happen to know a lot of great people leaving the VA, and they're ones we've relied to go to when we can't get anything done. And that's a real concern.
Yeah. So I'm worried.
I'm very worried too.
I don't like. I mean, if the secretary himself were in charge, I think he's a pretty good guy. But these people that have not been vetted, frankly, never served, frankly, teenagers. It sounds like it kind of scares me. I'm a little worried about that. They're not looking to help vets. They're looking to save money at every agency. Plenty of agencies out there that are probably inefficient. Not saying the VA is efficient, but what they're doing so far doesn't. They're not saying here's our plan to make things streamlined, to use software, to use AI. They're just saying I want to cut people, and then let's figure out a plan. That's scary. We're finally, as Carol said, we're finally getting all these decisions from the BVA, which is amazing because they've taken so long. The RO doesn't necessarily get it right every time, but again, just get us decisions, get us the CMP, get it moving so that we can get this through the system and the veteran benefits.
And it has been working much better than it's worked for years. It really has. So all we can say is what we're seeing happen to every other agency. And we've also heard that the posse, Elon Musk and his posse came into the VA, and there's just a lot of people who are unhappy. A lot of people are leaving. I mean,
and they're tapping in to know about everybody's benefits, who's getting what. Like, I don't think he should have that access. I mean, who the hell is he to be getting into your information?
So yeah, we're really concerned about this. And there are some good people that are going to stay because they need to retire and stay. But too many really good people are leaving. So we're really concerned. So you want to know it? We are concerned.
You set us up high, another step. Damn high horse. All right, unfortunately, it's going to be a quicker one today, guys. So we only have time for about 3 more questions. I apologize for having to late start.
Matt's such a deadbeat. He didn't pay his electric bill, and so he got his internet.
My internet wasn't working.
So we had to start later.
PhD had 3 DBQs for sleep apnea secondary to service-connected PTSD. I don't know. Yeah.
It's probably a DBQ.
Okay. With obesity as an intermediary step, VA acknowledged the diagnosis of sleep apnea, but denies service connection, secondary service connection. 2 DBQ denied connection. 3rd said nexus was established, currently at higher level review. Shouldn't they honor nexus and honor DBQ that said it was connected to obesity as an intermediate step and literature supports nexus? Should they? Sure. Will they? Probably not. But here's what I want you to do. Don't sit back on this, okay? Get a copy of all 3. Try to parse apart what the 2 negative ones didn't do. Find fault in them. Did they review the literature the 3rd one did? Did they thoroughly answer it with a rationale?
Yes.
Okay. Did they review all your records? Did they list what you told them? Okay. Go in there and show why those are inadequate. If the exam is inadequate, the 2-to-1 thing doesn't matter. If you can show both those exams are inadequate, whereas the exam you cited that was adequate actually looked at literature in addition to your file, you want to show the higher level reviewer why they should give credence to that one and disregard the other 2.
But remember, put it on a 4138, okay? Because if you just write it in a letter, they're not going to look at it.
Yeah, agreed. Chris, part 1 of 3, retired in 2000, 24 years later. I received 100% P&T. VA process was brutal and frustrating. That's funny. I received 20% in 08, then 70 in 19, but it wasn't until December 24 that I got 100%. Congratulations. They denied all 5 of my claims in 2022, but higher level review granted me 50% for migraines, 60 for skin disorder, 50 for knee injury, 10 for vertigo, and 0 for rhinitis. Wow. Well, congrats.
We need part 3.
Is there part 3? Yeah. Maybe not a part 3. Well, congratulations. I hope now, Carol's going to try to get you more benefits over here, but I hope that you can just get out of the system and move on with your life. That's a lot of fighting you did.
I know, but if the effective date is December, was the effective to say December of 24? I'm not sure. Would you go back to 1, please, Nate? 20, process brutal. Okay, 70, but it wasn't until December 28th. So if you were appealing all that time, I hope that it looks to me like you're saying you only got 100% effective December 24th. If so, I would really go to the BVA at least and get a chance to go all the way back. I don't know where you are right now. If you could, next one. Oh, okay.
All right. Last question here, unless we have Chris part 3. Okay. That's life. Good to see you. Migraines were increased, but denied sleep apnea, denied a 3rd time. I think that's enough fighting on my part.
Never. It's never enough.
I mean, if it's denied sleep apnea a 3rd time at the regional office, I would, as Carol would say, I would go to the board on this because they're, especially if you're saying sleep apnea secondary to migraines, they're going to, they just make crappy decisions on these. So
they aren't looking at any of the literature, and they have given this ridiculous rationale to the compensation and pension examiner, saying these are two different entities and they are separate entities. So that has nothing to do with it. Did one cause the other to happen?
Right.
That's the question. So remember, if you're getting crappy things like that in the opinion, you need to point out this isn't a correct opinion. It didn't say whether or not, even though they're separate, one could cause the other to happen or contribute to it. That's what you're looking for. So I'd be interested in what they said in that.
We'd also suggest that you do, these are your benefits. And unfortunately, one of the VA's best weapons is deny and delay.
Yep.
And if you feel you're entitled to these, we would strongly recommend you move on. But at the same time, if you feel like this is deleterious to your health, it's bringing you down because you're fighting and you're worried, maybe you let it slide for a little bit. But that's one of the things that.
Or maybe you get somebody to represent you, because that's what I tell my clients. This is my job. You take care of your health. You got enough problems. We'll take care of your benefits. So don't give up.
Yeah. All right, folks. Thanks for joining us today. We look forward to seeing you again next week for a non-abbreviated Q&A session.
Pay your bills, buddy.
It's little things. We appreciate all that y'all do and great questions, and love to see the knowledge you're bringing. Thanks so much and have a great day.